counsel appearing on behalf of the respondent, which is the state, Union of India, seeking permission to approach the judge. My lords, I would like to begin my submissions with this maxim: solus populi suprema lex, where solus republicae suprema lex. Well, that is, welfare of the people is the supreme law, or welfare of the state is the supreme law. What is the supreme law? Qua lex est suprema. This has been the question in almost every constitutional cases which this honorable court has heard before. And while adopting the notion that primarily you apply the doctrine of harmonious construction, and upon its impossibility to apply, this court has never shied away from holding that which advances the public interest as constitutional. Right from the Noor Agha case, we go back to the Noor Agha case of 2018, in which this court did not shy away from upholding the constitutionality of reverse burden clause, giving supremacy to the principle of solus republicae suprema lex. That is, private interests do not override public interest. Public interest outright seek private interest. Now, this is no case. This is not a case different from these other cases, because here there is a public interest involved, and that must outweigh private interests. On that strength of submission, I now seek the permission of this honorable bench. I will be making few common submissions, which I request that this court bear in mind before I proceed and argue on issues, the four issues in their isolated form. Now, these common submissions are, my lords, this court is not considering the legality of political funding per se, because that has been upheld by this court in a very long before case of Jayanti Lal Ranchod Das Koticha. So we are not considering the political funding legality per se by the corporate donors, because in that case this court clearly established that, look, whatever an individual can do can be done by a corporate person. So that is not under consideration before this honorable court. The second thing that this court has to bear in mind in appreciating the four issues is this, that this is the prior situation. What was the existing electoral funding prior to the introduction of this scheme? Because the present scheme has to be juxtaposed in comparison to the former one. Why I state this? Because governmental policies are sequential and often evolving. It is not our assertion that this scheme is be all and end all. Should any better, as suggested by my learned opposing counsel, better like digitalizing the bonds, these suggestions can be incorporated. We are willing to incorporate whenever suggestions come forward. But merely because there are some ifs and buts, the entire scheme cannot be declared as unconstitutional, because it is certainly a better development on the existing landscape. And throughout my arguments, I will establish that also. The third and the last thing is that this court has to take into account, and I am submitting few stats. This is the political funding data from 2004, financial year 2004 to 2015. My lords will note that funds from unknown sources tantamount to more than 80%. And known sources of funding is very limited. Now, what are these unknown sources? We never know. Why? Because of cash donations. Now, this is what we are essentially aiming at. My lords will agree with me here when I state that India is the most advanced digital economy. With the UPI in action, we have digitalized almost everything. And that is why, since we can afford to contribute and have any transaction cashless, the scheme has been. Now in order to promote people to use the scheme, we need to give certain incentives. Otherwise, why would I choose to not donate in cash and rather choose to donate by means of an electoral bond? Now, the incentive that is offered is that anonymity. Now, in the famous 9J judgment of Puttaswamy versus, there are two judgments, my lords are aware. One is the 5J and one is the 9J judgment. This court recognized the right to privacy. It rather called it in a different connotation. Said the right to privacy, in other words, is the right to informational self-determination. Now, self-determination as such was recognized again by this honorable court in Nalsar judgment. Now, informational self-determination encompasses in its ambit a lot of rights. The right to be forgotten including. I will decide which information of mine I will determine is available and not available. It is not up for public to determine. Now, in this judgment, my lords will note, their privacy was said to encompass three components: privacy as secrecy, privacy as anonymity, and privacy as control. Now, the anonymity factor is just a protective and an incentivizing, for just so people prefer the contribution through bonds rather than over cash. And the last thing that has to be borne in mind is that there is a conversion of clean money into unclean money. This is a very strange phenomenon, my lords. Now, I don't want to donate to a political party via digital means because I will be caught. I want to convert the money which I earn through legal means into unclean money just so I could donate to the political party. Now, that has to be borne in mind. If my lords have it, yes, sir. Yes, certainly, certainly. Yes. My lords, money is not clean. There are a lot of unclean money already in the which is counterfeit notes, all this. Yes, my lords. Yes, my lords.
You are saying that money is clean.
Yes.
And it is via how is
My lords, we are inviting, whenever somebody is purchasing the bond, clean money comes into the system. Even if it is an unclean money, you use it to purchase the bond. It is flowing into the system.
you suggesting that this is an instrument.
Yes.
Clean money, unclean money.
Into clean money. Yes, that is my argument.
Very dangerous proposition.
No, my lords, I am stating unclean money, which is not even in the sight of the government. That has to be come into the system. That has to be within the government records. That has to be into the economic system, so that we know how much money is in circulation in actuality. Because, my lords, there are two things. One is clean money is being converted to unclean money and is escaping the total economic monetary circulation from the economy. And the other way around is also happening. Now, this scheme aims to counter both. If my lords understand the same, I will further elaborate on the same. Now, the object behind the introduction of this was discussed in two Lok Sabha debates, 2016. Says that we are introducing this to cleanse the electoral process. Simple. Now, bearing these common submissions in mind, I will address the issues in isolation now. So, the first question, they have impugned, they challenged the scheme of being passed as a money bill. Now, my lords, first I will be addressing this issue under two prongs. One is, what is the existing jurisprudence with respect to speaker's discretion and certification of a money bill? And the second prong is this, that the amendments themselves squarely fall under Article 110. To be specific, Article 110 Clause 1, Subclause A, read with Subclause G. In light of the doctrine of pith and substance and the doctrine of ancillary and incidental powers. Now, my co-counsel happened to point out a minority judgment. Now, is there any locus classicus? Has this court been faced with a similar situation before? Yes, my lords, indeed. It's a 5-judge bench, Puttaswamy case, wherein the passage of Aadhaar Act as a money bill was in question. Now, in that judgment, only one person dissented, the Honorable Justice Chandrachud. Other than him, the CJ Deepak Mishra, Justice A.K. Sikri, A.M. Kanvilkar, and Ashok Bhushanji. All of them said that we admit pith and substance, and we admit, we hold the passage of the Aadhaar Act as money bill valid. This is similar case, my lords. And my lords, in order to invoke judicial review of a speaker's decision, if I may request my lords to kindly pick up the compendium of money bill, there we have submitted. The money bill compendium. I direct her ladyship's and lordship's attention to page number 150. I have flagged the same. This is the judgment of Justice Ashok Bhushan. He has made a pertinent point, distinction between procedural irregularity and illegality. Now, judicial review. Now, my lords, there is an Article 122 shielding legislative procedure from being judicially reviewed. Now, that only amount that one I admit to the extent that it says that can be invoked. That shield acts as a shield so long as there is a procedural irregularity. The moment there is an illegality, Article the shield of Article 122 is taken back. Now, I will be establishing, my lords, that now when there is no illegality, there is no judicial review. And what is illegality? Now, if the amendments do not fall under any of the limbs of Article 110, then it is illegality. But if it falls, then it is not an illegality, and as such, this court will not have to tone down on my submissions, will not have jurisdiction over that by virtue of Article 122. My lords, I will be explaining this. Now, taxation, my lords, Article 110, Clause 1A, if you read, my lords, the wording of it deals with A to Z of taxation. Now, taxation does not just begin with levy and end with collection. It begins far before. Why do I state this? All the things which I do to augment the taxable income on which I can tax, that itself is taxation. Now, in my submission, I am submitting for my lords perusal these two judgments. First, but in particular, please refer to how are you to construe. Sorry. This is the Godfrey. This is the Puttamma versus State of Kerala judgment. That is the yes. Yes. Separated this. Now, why does you construe any wordings, particularly with respect to matters of taxation? Wider, broader connotation is taken into account. And this judgment of Godfrey Phillips, see, my lord, taxation includes all events. I am submitting. Can't be stated. My lord, taxation includes all taxable events. Now, my lord, to analogize the same. Now, there are I go for fishing, and there are only 2 fishes in the pond. Now, whatever I do, whatever endeavors I make to increase the total number of fishes in the pond, that would itself amount to fishing, my lord. Now, I stated that we are preventing clean money from being converted into unclean money for the purposes of electoral funding. And from unclean money, all this. Now, what does this essentially do? It brings more money into the system. And all this money has been escaping from taxation. Now, when I am doing something to augment the total taxable income in the economy, that itself amounts to taxation. That Article 110, Clause 1, Subclause A, when read with incidental and ancillary. Now, this measure which I have taken to augment the taxable income is incidental and ancillary to taxation. As such, when the scheme falls under Article 110, Clause A read with G, I don't think so that the judicial review of this Honorable Court is invoked. And so far as existing judicial review on Speaker's decision is concerned, I again request my lords to kindly pick up the compendium. In that, the majority judgments, I have pinned the minority judgment, which is Chandrachud's, Justice Chandrachud's. Other majority judgments, I have opened it. Now, there my lords will note, in particular, refer to page number 11 to 13, the manually paginated page number, not the ones below, the manually paginated one, the money bill compendium. Now, 11 to 13, my lords will note there, but first my lords refer to page number 7, please. Now, there are list of judgments. Now, he happened to mention Quixote Olohan, wherein judicial review was exercised by this Honorable Court with respect to Speaker's jurisdiction, Speaker's discretion. Now, Quixote Olohan was a case which dealt with para number 6 of the defection law, 10th schedule. My lords are aware. Now, in all these judgments, not only Quixote Olohan, now that Speaker here was acting in a judicial capacity. He is judging. His say is final when somebody's disqualification is under question. Now, this is something he is acting as a judge here. He is in a judicial capacity. There we submit that ultimately judicial review exists. We bow down to that submission. But when certification of money bill is concerned, he is not performing any judicial duty. there my lords will agree. All judgments, all existing judgments, wherein this court has exercised judicial review on speaker discretion, relates to only those cases wherein the speaker has acted in a judicial capacity. Now, certification of a money bill is not a judicial capacity. When certifying a bill, the speaker is not acting in a judicial capacity, and as such, no judicial review of this honorable court is in due. Now, if I have satisfied my lords so far as the passage of the same is concerned, I would address the second issue. The second issue, I will be arguing the second issue under five lines of submission. Prior to that, my lords, we are not disputing whether the citizens have right to know. Obviously, they have. That is not under dispute. But here, the right test to be applied is not a test of proportionality, but rather the test of double proportionality. Now, proportionality was envisaged to meet circumstances wherein you have one fundamental right on the one hand. On the other hand, you have a reasonable restriction, which is allegedly infringing the fundamental right. But when that reasonable restriction is in itself in the nature of a fundamental right, now you have to balance two fundamental rights. Now there the proportionality test fails. Now the proper test to be applied on is the test of double proportionality. I refer my lord's attention to the third compendium which we have submitted, which deals with heading doctrine of proportionality. Now, my lords are aware that 5 tests of proportionality exist, 4 being evolved in modern dental college and sufficient and necessity test elaborated in Anuradha Basin, and the 5th test which says that there should be safeguards to ensure that it is not misused, which was held in Gujarat Mahasabha case. Now these 5 tests are there, they are outdated. Now when 2 fundamental rights are there, you cannot apply proportionality test. You have to apply double proportionality, which deals with only 2 stages. Please refer to the compendium I have submitted. There you will find this was adopted from Campbell versus MGM Limited and subsequently referred in another case of CPIU by Honorable Justice Chandrachud himself. Now, he adopted the test. When 2 conventional rights are in contradiction with one another, then you apply double proportionality. What do you see in double proportionality? 2 tests, necessity test and suitability test. If the scheme passes muster, then the scheme is constitutional. Now, in the necessity test is similar to the necessity test under proportionality. Least effectiveness, it should be least impairing the other right, and it should also be most effectively achieving the object. Now, I submit, my lords, this scheme undoubtedly is a better development on the previous scheme. Now, in the previous scheme, this is I submitted data through which the same can be established. Well, let's just pardon me. Yeah. Well, this is the popularity of the scheme. Compared to electoral trust versus electoral bonds, the moment we introduced the electoral bond scheme, that was preferred as a medium of contribution over electoral trust. When the public themselves are welcoming the scheme, who is the petitioner to dispute it and challenge the same? The state itself is agreeing to the same. Now, anything which is the legislature is elected by the public, a presumption of constitutionality mentioned. Now, when the public itself is welcoming of the same, I don't think so the petitioner has any locus challenging the petition in light of the data I submitted. My lords, one essential thing is the right to information. It cannot lie against us. Now, the scheme, I am submitting the scheme for my lords' perusal. Now, the anonymity clause under 7 clause 4 operates even against the government. Now, my lord, there are a lot of bodies which are appointed, whose appointing authority is the central government. Merely because appointing authority is the central government, there cannot be an implication that it would abuse or obstruct the constitutional discharge of those functioning of those bodies of which it is the appointing authority. I mean, that is not some reason to suspect, these all are baseless and entirely hypothetical. Yes, my lords.
But more information is available to the government.
No, my lords.
And less information is available to the public at large.
Yes.
Whether that is...
there is no information available to the government. My lord, the issuer of bonds is the SBI.
That's
Now
right.
it's a third party. Yes, ma'am.
But the government has access to the information that is.
There is no proof. There is no, my lord, the anonymity clause, if I may submit the electoral bond scheme, my lords have the same. There 7 clause 4 you read, my lords, clearly says that it under no circumstance, only this court can open that shield. This court, if suspects quid pro quo, as they have pointed out, this court can order that give us the details. Only in that circumstances can the wheel be lifted.
You mean to say that nothing is disclosed to the government?
Yes, that's my submission. My lord, these are just assumptions. You do not have any proof that SBI has disclosed the data to government. Do you have any? No. Since 2018, the scheme is on. No, my lord, it's a public sector bank. We cannot call it a government instrument. For that matter, even RBI is a government instrument. If you perceive it like that, but each are performing their constitutional role or statutory role as supported. Now, just because one is the appointing of an authority or the other, in fact, for that matter, my lord, doctrine of separation of powers itself says, in order to have checks and balances, all have to work in coordination with one another. This is something, just because it is the appointing authority, you cannot assume that it will have access until and unless you have proof that it has had access. That is one submission that I make. Now, my lord, so far, on the strength of this submission now, right to information, you refer to the RTI Act preamble as well as this judgment. It can lie against that government, those information which is in the possession of the state. Now, this information they are asking is not in the possession of state, rather in the possession of a third party which is SBI. How can right to information lie against the government? When we do not have an information which is not in our possession at all, judgments are very clear. You can ask only that information which is in the possession of the state. You cannot demand that which is not in the possession of the state at all. So that is one submission. Now, my lords, the right approach here, in our humble opinion.
Will the SBI fall within the definition of a state?
No, my lords. Article 12 is very clear. Article 12 does not involve SBI within the ambit of state. Now, my lords, the right appreciation of the scheme is the doctrine of mischief rule, as evolved in Haddon's case and subsequently adopted in Indian cases. One such case I am submitting, which is Sorda Devi case, CIT versus. Now, this case, as evolved in Haddon's case, 1584 case, House of Lords, deals with 4 stages. Whenever you are appreciating a policy or legislation, you ask these 4 questions. The first being, what was the common law prior to the policy? In our case,
There are certain decisions which say that a bank, a public sector bank, is an instrumentality of the state.
Instrumentality test. Now, the current test to determine whether a body is a state or not is the functionality test, not the instrumentality test. I beg your pardon, but instrumentality test is outdated, my lords. Now, my lords, we have to apply the mischief rule. The first stage, we ask the question: what was the common law prior to the scheme? The common law was very simple, the electoral funding. I draw your attention to para number 6, 7, 8, 9 of the proposition. Very clear. Electoral funding was really vague and it had money laundering, all sort of practices could be practiced. Now, the second question that
What do
we
you
ask.
say about the money laundering possibility which has been pointed out by the other side?
Again, it's a possibility, no proof. We can always split hairs of everything. Any person who is good, as lawyers, I think.
No, it becomes proof only when it is done.
Yes.
But is there a possibility of it being done?
My lord, that is for this court to answer. Can you challenge the scheme on mere possibility of it? Possibility of its misuse. I have a maxim here: abuses non-tollate ism. Merely because a law is abusive, you cannot strike it down. Merely because it may be abused, you cannot strike down that law. Until unless you have proof that yes, it is being abused. And they have not submitted any proof. The scheme is in operation from 2018 to until now. Any proof of abusing, any stat, any data, nothing whatsoever. So this is my submission. The scheme is successful. I have submitted a data which proves the same. If I may be allowed to argue for some other time, certainly. Now, I'm going back to the mischief rule. Now, second question that we ask is, what is the remedy proposed by the legislature to? Now, simple maxim: opprimere mele, promovere remedium. Suppress the mischief. The mischief is black money and all this, and the remedium which we have provided is the scheme. In the third stage, we ask that whether the scheme One second, words. First of all, I wanted to submit this. Now, this is the electoral bond scheme in particular, and object to object. Every clauses on the one hand you have, on the other hand you have what is the object it strives to serve. My lords may refer to the same. Every clause serves the object. And cumulatively, all these objects, serve for 3 to 4 purposes, which I have already discussed before this honorable court. Now, going back to the Heddon's case, my lords, the rationale behind the object, the introduction of the scheme. Whatever scheme you introduce, what is the rationale? That is also there. Now, the right test is apply the mischief rule. And if this honorable court applies the mischief rule, the scheme passes muster. And obviously, I have already established that it also passes muster so far as application of double proportionality test is concerned. Now, I have just
What exactly is the mischief rule?
Mischief rule, my lord.
What is exactly the mischief rule?
The mischief rule simply says, my lords, while interpreting a law, an impugned any policy or anything for that matter, you suppress the mischief and you advance the remedy. Opprimere male, promovere remedium. 4 stages I already took my lords through the same. The scheme passes it. Now I have only 2 more submissions. Now we need to balance 2 rights. One is the right to privacy and the right to information, which we have balanced already. If you may refer to the table, we have formulated table in our memorial. Please kindly refer to the same. Page number 28. My lords have the same. Page number 28 of the memorial. I can submit one additional memorial in case if there is shortage of memorial. Do you want me to submit, my lords? My lords, on the left hand we have written what is disclosed, facilitating the right to information. On the other hand, we have written what is not disclosed, facilitating the right to privacy. Now, what is disclosed? Well, under section 399 of the Companies Act, which is the ground for doctrine of constructive notice under the Company Act, company law. Now, every person has a right to ask the registrar or even digitally access the financial statements of a company. And the company has to provide the true and authentic view of its financial statements. So you can access it from there. And my lords, furthermore, the EBS scheme mandates political parties to file audited accounts, and still section 139(4)(b), capital B of Income Tax Act also makes it incumbent for the political parties in order to avail tax exemption benefit to submit a record of donations. So that is something which is disclosed. Sufficient disclosure is there. And what is not disclosed is just this. That is not fully, it is not that we are imposing a blanket ban on non-disclosure. That wheel can also be lifted. 7 clause 4 clearly provides for the same. Whether if it is established before this honorable court that there has been quid pro quo as alleged by them, then this court is competent enough to order disclose it, who bought which bond. This court can do. So it's a correct balance has been established. And one important argument is there relied on ADR and PUCL. It will not apply in our case. But ADR and PUCL dealt with right to information of voters, candidates contesting voters with respect to candidates contesting the election. Now, donors are not candidates contesting election. Please refer to the compendium I submitted, right to information compendium. I have highlighted candidates word. These 2 judgments only dealt with right to information of the voters against the candidates contesting elections. Whatever it is, criminal antecedents, because you are gonna be tomorrow the legislator, my leader. So as such, I ought to know what is your antecedent. All information necessary for me to formulate an opinion to vote for you. But a donor cannot be put in an equal position as that of a voter. Now that, if putting so, will amount to non-classificatory arbitrariness. Now my lords are very well aware that there are two types of arbitrariness. One is classificatory arbitrariness, the other is non-classificatory arbitrariness. I am submitting a judgment which dealt with the same, which is the judgment of, this is the judgment, State of Tamil Nadu versus, there are two types of arbitrariness. Now my lords, I seek extension. My lords, it is upon your discretion to grant this. Just 2 minutes. I'll wind up here. That is my last submission. Please. Okay, my lords. I'll rush my case. Much obliged.
Lecture. Much obliged, Your Lordship. Your Lordship, I'll be advancing arguments for the third and the fourth issues. The third issue, which pertains to the powers of judicial review, and the fourth issue, which pertains to the question of violation of principles of free elections, which is also a part of the democratic setup and basic structure of the Constitution, Your Lordship. Your Lordship, the third issue, which reads as under whether matters concerning the modus operandi of political funding amount to the policy decisions within the domains of government and free from judicial scrutiny, Your Lordship. Your Lordship, under this, I'll be advancing 4 lines of arguments. Firstly, Your Lordship, the principle of non-interference of policies, Your Lordship, so long as the policy itself is not illegal. The legality of the policy is not in question. Secondly, Your Lordship, the presumptive benefit of good legislation, which has to be attributed to the legislation here. Thirdly, Your Lordship, the laxity which has been granted in economic matters, which is coming again from the domains of legislation. And lastly, Your Lordship, the scope of judicial review under Article 13 and 19, Your Lordship. For the first issue, before I make any submission, Your Lordship, we are not contending whether the court is able to judicially review as such. However, Your Lordship, since this scheme is not at all illegal, thereby the court has to apply some laxity, Your Lordship, while reviewing the same. Your Lordship, such has been also mentioned in case of premium granites versus State of Tamil Nadu, as mentioned in the compendium, Your Lordship, Part 2, Judicial Review Part 2, Your Lordship, on page number 107. Your Lordship, coming on to the second submission of third issue. Your Lordship, the article of 122 of the Constitution comes into play, and the presumptive benefit of wise legislation has to be attributed to the legislator. Your Lordship, since Supreme Court cannot inquire into the policy as established by the constitutional provision under Article 122, there is presumption. Now, what this presumption is, it is the presumption of beneficial legislation, and this beneficial legislation has been also granted under the case of Swiss Rebels versus Union of India, Your Lordship. Your Lordship, the case has also been referred into compendium, Part 2 of Judicial Review, Your Lordship, for a perusal, page number 81. Your Lordship, it is presumed that the legislature has enough means and tools to provide for a good legislation. It has all the necessary expertise, experts' opinion, as well as proper understanding of the needs of the people of the state, Your Lordship. Your Lordship, in that respect, the third submission comes into play, which is the laxity and deference, which is granted to these economic matters. Your Lordship, further, through cases on which I am relying, Your Lordship, the cases on which the respondents have placed reliance is RK Garg, as mentioned in the second part 2 of Judicial Review, mentioned on page number 20, Your Lordship. Rustam Kaswaji Cooper, Your Lordship, versus Union of India again, in the first Judicial Review compendium, page number 60, Your Lordship. And lastly, Your Lordship, Balco's Employees Union versus Union of India, and again, the second part of Judicial Review, page number 23, Your Lordship. Your Lordship, further, relying upon also the presumptive benefit that has to be attributed to the legislation, there is a certain amount of laxity. In all these cases, there has been a certain amount of laxity which has been granted to economic policies while exercising judicial scrutiny. Your Lordship, further, Your Lordship, again referring to Swiss Ribbons versus Union of India case, the principle of beneficial legislation, which is again has always been under play. It helps this scheme, Your Lordship. Now, how is this beneficial? The question might arise as this: how this scheme is beneficial to the country, Your Lordship. Your Lordship, this helps the macroeconomy, Your Lordship. How, Your Lordship? Your Lordship, the question of how can be answered through proper channelization of banking instruments, Your Lordship. Now, all this money is channelized to trackable banking instruments. In this way, it is helping the economy to regulate the matters of economic nature, Your Lordship. Lordship, lastly, Your Lordship, the scope of judicial review. Your Lordship, in Keshava Madhava Menon versus State of Bombay, Your Lordship, this is a case which the respondents are submitting. The highlighted aspect, Your Lordship, on second and third page. Your Lordship, it says that the Supreme Court has to judicially review any scheme or law under the actual spirit of Constitution. Now, what petitioners have evoked is the presumptive benefit, assumptive constitutional spirit, Your Lordship. Now, the Supreme Court cannot exercise its judicial review on assumptions. It has to be an actual provision which is under the Constitution. As such, the petitioners have no stance here, Your Lordship. Coming on to the fourth issue, Your Lordship, which reads as under whether the electoral bond scheme tampers with and distorts the principles of fair election, which is also the part of basic structure of the Constitution. Your Lordship, it is vehemently contended that it does not tamper with or distorts any kind of fair principles of fair election, which is also part of basic Constitution, Your Lordship. Your Lordship, basic structure of Constitution, as also relied by the petitioners, has been dealt with in Keshavananda versus State of Kerala and Rajnarayan case, Your Lordship. Your Lordship, I'll be making submissions under two lines again, Your Lordship. Firstly, Your Lordship, the question of structural distortion, which deals with both incumbent bias as alleged by the petitioner, as well as the uneven playing field, also alleged by the petitioners, Your Lordship. These two contentions do not hold water at all in this court, Your Lordship. First line of submission. Secondly, Your Lordship, the scheme is not arbitrary, as again alleged by the petitioners, Your Lordship. Your Lordship, first, I'll be making a common submission to this issue, which is we are not concerned with the corporate funding. Again, as my co-counsel asserted in the beginning, that we are not concerned with the legality of corporate funding itself. However, Your Lordship, now what does come into play is the question of structural distortion. Your Lordship, these structural distortion comes into play in two aspects. Firstly, with incumbent bias, meaning the ruling government will receive more fund, Your Lordship. And secondly, uneven playing field. Uneven playing field as if, Your Lordship, dealt in that all the candidates are not favoured, Your Lordship. There are some parties which are favoured and not the others, Your Lordship. Your Lordship, the incumbent bias as put forth, alleged, Your Lordship, there is no data to substantiate the same, Your Lordship, on the part of petitioners. And as such, there can be no incumbent bias. Further, Your Lordship, there have been submissions, Your Lordship. Since the electoral landscape itself forms opinions on governments, ruling governments, Your Lordship, there would always be differing opinions as well as the donation of individual donors, which would be affecting the present electoral landscape. Your Lordship, as such, the contention of incumbent bias is vitiated.
The government knows that who has donated to them.
Your Lordship, the government does not know.
Does not know.
Does not know.
Okay.
Lordship.
How?
Had the government known,
The bonds are handed over to the government, isn't it? The party which is
Your Lordship,
ruling.
the bonds are handed over to the political party. Now the political party does not know who has contributed or who has donated. Your Lordship, only the amount is received by the political party, Your Lordship. And as such, this also works in prevention of victimization and retribution by the ruling party. Your Lordship.
And why is it that ruling party gets more than the...
Your Lordship, this is the contention
party
raised.
opposition?
Indeed, Your Lordship, this is a contention raised by the petitioners again, Your Lordship. However, there is no data to support. Neither is there any such articles or any matter as such which is in support of this contention, Your Lordship. If Your Lordship succeeds. Your Lordship, moving on to the uneven playing field, Your Lordship. The uneven playing field as contended by the petitioners again, Your Lordship, it does not hold any water in the court of law. Your Lordship, this situation does not arise at all, since there would always be candidates with minimum voters and there would always be parties with maximum amount of appeal in the electoral process, Your Lordship. Your Lordship, again, because it is part and parcel of this electoral landscape, the uneven playing field, so long as it is not arbitrarily in itself. If two parties are contending and one party is arbitrarily getting all the votes, Your Lordship, so long as this is not the case, this uneven, the question of uneven playing field cannot be questioned, cannot be put into the court of law, Your Lordship. Your Lordship, dealing with the same, Your Lordship, the electoral bond is in actuality, Your Lordship, protects the privacy of donors, as again asserted by my co-counsel, Your Lordship, put forth. Now, this is again through banking channels, Your Lordship. Your Lordship, in this way, the amount received, only the amount received, not the party names, only the amount received by the political parties is matched with the number of donations made by the donors, Your Lordship. Neither party gets to know who has donated to whom, Your Lordship. In this way, the anonymity is secured, Your Lordship. Lordship, now the fourth issue, the second submission, Your Lordship.
It is only disclosed to the bank.
Lordship,
As to particular electoral bond is to go to which party is only disclosed to the bank
indeed, Your Lordship.
by the donor.
Indeed, Your Lordship. Now, what donor does is walks into a bank. Your Lordship,
The bond is encashed by the person who gets it, is it not?
indeed, Your Lordship. The bond is encashed by the party within limits of 15 days.
Yes.
Your Lordship, the SBI, Your Lordship, SBI ensures that these bonds, Your Lordship, since these are bearer instruments, Your Lordship, it is ensured that these reaches to the parties per se, Your Lordship, to which these donations have been made. SBI ensures that. This is the part of the scheme, Your Lordship.
You mean to say it's the SBI which hand over the bonds to the parties concerned according to the instructions received by them? Is that so?
Indeed, Your Lordship. Your Lordship, Your Lordship,
See, a person goes to the bank, gets a bond,
indeed, Your Lordship.
and then does he not hand it over to the person who is to be benefited by that?
No, Your Lordship.
No.
Your Lordship, person walks into a bank, submits the funds, Your Lordship, gets the electoral bond, Your Lordship. Now, this electoral bond is further into particular SBI branches it is submitted. Now, from there, Your
Who
Lordship.
is submitting it? Is it the person who is getting benefited by that, or the person who has got it?
Your Lordship, the person who is making the donation, Your Lordship, the person who is making the donation is submitting it to the SBI, Your Lordship. Now, these SBI banks, they are delivering it to the person entitled to the bond, Your Lordship, the parties, Your Lordship. In this way, neither the party knows who has given them donations, nor does the party, the donors, get to tell the parties that they have donated to him. Your Lordship, the principles of fair election are in this way maintained, not violated. Your Lordship, indeed, Your Lordship. Your Lordship, as per the wishes of the donor, Your Lordship. Yes, indeed, Your Lordship. Pardon, Your Lordship. The council could not listen. Indeed, Your Lordship. Your Lordship, for such a contention, Your Lordship, indeed, Your Lordship, the courts, Your Lordship, the SBI, Your Lordship, the issuing bank, Your Lordship, it has certain courts, Your Lordship, to ensure that the person to whom it is designated, only that person gets, Your Lordship. Now, the KYC details ensure that the person who is donating submits their information. Now, on the basis of the person who is submitting to these parties, Your Lordship, it is ensured that the bond which is being purchased on the name of whom the person is issuing, Your Lordship, now that very person on the donation is made on that very person, Your Lordship, in the name of that very person, if Your Lordships are satiated. Your Ladyship, I'll be drawing an analogy.
You mean to say that the instructions are given to the person who is the donor to give this particular
Your
bond?
Lordship, the donor is donating from himself, Your Lordship.
Yes,
He
to
is not
the bank.
under.
He purchases the electoral bond from the bank, giving instructions thereby that it has to be donated to so and so party.
Indeed, Your
Is
Lordship.
that so? And it is for the bank to give that particular bond to the particular party who is the beneficiary. Is that so? Is it not the person who is actually donating to hand over the bond to the party which is receiving it?
Your Lordship, the person who is donating, Your Lordship, this is the work of the bank. This is why the banks are there, Your Lordship. It is acting as the channel, Your Lordship. The bond purchased, if I am the donor, Your Lordship, I am going into the bank, doing my KYC. Now, I am making certain donations, Your Lordship, in amounts of 1,000, 10,000 and so forth, Your Lordship. Now, when I am making these donations, Your Lordship, I am getting that electoral bond. Now, Your Lordship, I am in the name of whose party, Your Lordship, the party which I am supporting, Your Lordship, to which this donation has to go. I am making that donation to that party's name, Your Lordship. These electoral bonds are now given to SBI, Your Lordship. Now, these donations, Your Lordship, these electoral bonds now are given to the respective parties, Your Lordship. So, there is a proper channel, Your Lordship, to which it works in the favor of both, Your Lordship, to the anonymity as well as principles of fair election, Your Lordship.
Okay.
Your Lordship, the last line of submission, Your Lordship. The scheme per se is not arbitrary in nature, Your Lordship. There is no need, because Your Lordship, there is something again that my co-counsel was trying to make, Your Lordship. There is certain classificatory arbitrariness and non-classificatory arbitrariness. Your Lordship, if I may be given some extension, Your Lordship. Much obliged, Your Lordship. Your Lordship, these donations, Your Lordship, talking about the classificatory arbitrariness, Your Lordship, this might have been the case of classificatory arbitrariness had the legislation classified the group of donors, Your Lordship. Lordship, it is contended that when there is a classification, there has to be an intelligible differentia on the basis of which the classification is made. Now, Your Lordship, it would amount to classificatory arbitrariness if there is absence of intelligible differentia. Now, Your Lordship, had there been a classification without any intelligible differentia, this would be arbitrariness. So, because you are making a classification and there is no intelligible differentia, it is arbitrary by the virtue of it, Your Lordship. Therefore, Your Lordship, when there needs to be a classification, the legislature has skipped this process in order to not make it arbitrary in nature, Your Lordship. Your Lordship, there have been cases, Your Lordship, where this provision, Your Lordship, the guidelines on which the classification has to be made is given, Your Lordship. These cases are in the Special Courts Bill, Your Lordship, of 1978. Lordship, there have been 13 guidelines on which the classification has to be made, Your Lordship. Now, the legislature is not at all transgressing these guidelines, Your Lordship. It is within these legislative guidelines and judicial guidelines, Your Lordship. Lordship, lastly, Your Lordship, there have been cases where the corporate funding is challenged, Your Lordship. Your Lordship, the cap of corporate funding has been challenged. Your Lordship, it is humbly submitted that in the case of Arizona Free Enterprises Club's Freedom, Your Lordship, of United States, the flag. Lordship, other countries too have been facing this issue, that whether there should be a cap or there should not be a cap. Lordship, it has been held in these judgments of various other countries that when we apply cap to any corporate donation, Your Lordship, any corporate funding, it is violation of freedom of speech, Your Lordship, the First Amendment of United States, Your Lordship. And thereby, Your Lordship, further it was again held in the same country, Your Lordship. This is a case, Your Lordship, which was against Federal Election Commission. Again, Your Lordship, this case as well dealt with the cap of corporate funding. It was held in this case that when we apply cap, the same thing was held, Your Lordship. It was further substantiated that it is violative, Your Lordship, violative of the First Amendment again, freedom of speech, and as such, it cannot be held that there should be a cap, Your Lordship. If we apply a cap to corporate funding, it would amount to violation of freedom of speech, Your Lordship. Your Lordship, the petitioners, Your Lordship, the challenge of shell companies, Your Lordship, as far as the challenge of shell companies is concerned, Your Lordship. Now, Your Lordship, the petitioner stated that there is, because there are shell companies and they do not have funds, Your Lordship, how would they fund? This is the line of submission they made, Your Lordship, as far as my knowledge goes, Your Lordship. Your Lordship, it is brought to your attention that shell companies are shell companies because they are made for funding, Your Lordship. They do not have entirely backing, Your Lordship. The company does not make an entirely new company, makes it work and then donates, Your Lordship. These companies are made for the purpose of corporate funding. Your Lordship, since these are made for the purpose of corporate funding to exercise within the cap, there is conversion of clean money to unclean money. Now when we remove the cap, the corporate body itself can donate without the use of shell money. In this way, the ostensible object and the real object, as held in Joseph Shine case versus Union of India, it is, Your Lordship, it is following the test, Your Lordship. It is passing the test of object test, Your Lordship. Further, Your Lordship, the classification does not need to be made. In this way, Your Lordship, the scheme not only follows the principles of fair election, Your Lordship, it does not violate any kind of basic structure of the Constitution itself, Your Lordship. Your Lordship, permission to proceed with the prayer, if Your Lordship says. Much obliged, Your Lordship. Your Lordship, it is humbly prayed before this honourable court that it may be graciously be pleased to uphold the Electoral Bond Scheme 2018 and the 5 amendments incorporated in the Finance Act 2016 and 17, Your Lordship, as constitutional. Now, Your Lordship, again, Your Lordship, the second prayer is to uphold the passage of 5 amendments incorporated in the Finance Act 2016, Your Lordship, and pass any order as they deem fit. Much obliged, Your Lordship.